on original charter. And this is Article 9-B. Article 9-B, Paragraph 2, Subparagraph 1 of the 1987 Constitution. Why? Because in our area of jurisdictional conflict, in case the choice is labor arbiter, GOCC with original charter. How do you know that there is an original charter? This is your guide. Look at the facts of the problem, whether the GOCC was organized under the old Congress. It was organized by virtue of a Republic Act, a law passed by Congress before martial law. That was the legislative fire creating this GOCC. Or during martial law, the GOCC may have been created by virtue of a PD, a presidential decree, pursuant to the legislative lawmaking power of the late President Marcos. Or a GOCC during the Freedom Constitution under the late Cory Aquino. Usually, executive orders were drafted by former Joker Arroyo, then Executive Secretary, in creating then, under the Freedom Constitution, GOCCs via executive orders. And when this Congress, now in place, based on the 1987 Constitution, was convened, and after election, they resume office. GOCC may likewise be created by virtue of a Republic Act or a law passed by Congress. Any of this is an indication that the GOCC has an original charter. If it has an original charter, and the choice is labor arbiter versus the Civil Service Commission, then it is the Civil Service Commission that has jurisdiction over aggrieved employees of the GOCC with an original charter. But if your indication, based on the facts given you, is that the GOCC has no original charter because it has not been created by any of the four that I told you, it was incorporated with the Securities and Exchange Commission under the General Corporation Code, then that GOCC has no original charter. And if you will be asked, are the provisions of the Labor Code applicable to the employees of this GOCC without original charter? The obvious answer is yes, because it has no original charter. Example of this would be the Food Terminal Incorporated. For so many years, we were the ones who registered the Food Terminal Incorporated, then under the Ministry of Human Settlements at that time with the SEC. So employees of the Food Terminal Incorporated were able to form unions of their own. They were governed by Book 5 and the Labor Code provisions. Why? Because they have no original charter. Likewise, the employees of the defunct University of Life Foundation were able to form unions of their own, availing of the provisions of Book 5 of the Labor Code as amended. So you have to distinguish whether the GOCC has an original charter or not. As was the experience in the past, there was about a year where there was an overflowing questions in labor. So this question that we are now, this matter that we are now discussing, was asked in political law. So before we leave GOCC, determine well whether in the facts of the problem, of the bar question, whether the GOCC has an original charter or not. And the third one, I want you not to miss this third one. Corporate officers. This is again another bar matter that, if not asked in labor, will be asked in mercantile law or in commercial law. Okay. So, corporate officers. Of course, the $64 question is, how do you know that one is a corporate officer? Okay. These are your parameters. The position is in the bylaws. So the bylaws of the corporation would be the Bible of how the corporation is run. It will determine how the corporation will operate. As I've said, it is the Bible of how the corporation is to be run. So a position is there. Vice President for Controllership. And supposing A is interested in that position, what should be done? A should be appointed by virtue of a board act. What do you mean by a board act? Majority of the members of the board of directors of the corporation must, elect him to the position of Vice President for Controllership. If after 2 years, Mr. Ray, the Vice President for Controller, would no longer be reappointed or elected as such, then it must likewise be by virtue of a board act. So appointment by virtue of a board act, the position is in the bylaws. Non-reappointment thereafter is by virtue of a board act. Okay. Now, all the materials that you have in your book of Buddy Pokis, Chan, and the rest, Azucena, are decisions of the Supreme Court prior to July of 2000. So this is the cutoff date. What's the importance of July of 2000? This is the effectivity date of the new Securities Regulations Code. And so, what's the importance of this cutoff date? Because prior to July of 2000, the jurisdictional conflict on corporate officers' problem or controversy is labor arbiter versus the Securities and Exchange Commission. So all the cases that you have read there, Lawson versus Philippine Airlines, Espino versus Philippine Airlines, that one case that I also decided, Ongkingo versus Galeria de Magallanes. In that case, the SEC had jurisdiction, not the labor arbiter, not the NLRC. Okay. So here will now be the problem. There will now be 3 choices plus another one to make it 4 on jurisdiction. So supposing A was dismissed was not reappointed as such by the corporation's directors after July of 2000. He is aggrieved and he now consults you where to file his case. So we now add another dimension because the non-reappointment was after July of 2000. So the choice is labor arbiter, Securities and Exchange Commission, and the appropriate regional trial court designated as commercial court. The answer is obvious. It is the RTC, designated as commercial court. Because after July of 2000, all inter and intra-corporate controversies were transferred from the SEC, from the Securities and Exchange Commission, to the appropriate regional trial courts designated as commercial courts. So the answer would be appropriate RTC designated as commercial courts. But again, if the non-reappointment was before July of 2000, the answer is SEC. Okay? Now, another situation that may be asked, a strong possibility. The position of this person in the corporation is not in the bylaws. It's not in the bylaws. So, what is the position? Is Vice President for Labor Relations. How was it created if it is not in the bylaws? By virtue of a board resolution approved by the board of directors of the corporation under its broad enabling powers. So, B is interested in this Vice President for Labor Relations. How can he become a corporate officer? He must be appointed by a majority of the directors of the corporation. And again, if after 2 years he was not reappointed or re-elected as Vice President for Labor Relations, he may now file his case. He will now ask your advice. Labor arbiter or SEC or the appropriate regional trial court. Okay, facts of the case will disclose that he was not reappointed after July of 2000. The obvious answer is the appropriate regional trial court. Okay, the variation is, first one, the position is in the bylaws. Second one, the position is not in the bylaws, but it was created by virtue of a board resolution. Nonetheless, for your bar in October, B is a corporate officer. Now, there is a variation of the cases of corporate officers A and B. In the mid-2005, there was this case of Nakpil versus IBC 13. Nakpil versus IBC 13, Channel 13. He was appointed by the general manager of IBC 13 to the position of assistant general manager. So Nakpil was appointed. His position was not in the bylaws. It was not a board-created position. But the general manager, after appointing him as assistant general manager and controller, elevated his appointment to the board of directors that approved the same. Okay. So this case now went up to the Supreme Court. The issue was, according to Nakpil, the then appointed AGM, assistant general manager, is the labor arbiter that has jurisdiction over my case, not the RTC. Because my position is not in the bylaws, my position was not created by virtue of a board resolution. Management of IBC 13 insisted that it is that the labor arbiter has no jurisdiction, rather the appropriate regional trial court has jurisdiction over the case of the first name of Mr. Nakpil is Didi Daddy. Okay, so Supreme Court ruled that even if, as a variation, our first two discussions, not in the bylaws, not created by virtue of board resolution, was nonetheless a corporate officer because of the approval of the majority of the board of directors of IBC 13 of his appointment as assistant general manager. So it's the appropriate RTC that was ruled to have jurisdiction over the case of Nakpil. Okay, so that's the third possible example, Nakpil versus IBC 13. And the last example will be the case of Miss C, a chief accountant. Miss C, the chief accountant of the company, was appointed by the president of the corporation. After 1 year, she was dismissed by the same president of the corporation. Her position is not in the bylaws. Her position was not created by the board as chief accountant, but in the regular plantilla position of the company. Ruled whether the labor arbiter or the appropriate regular court, RTC has jurisdiction. Okay, so you analyze the problem. Is the chief accountant a corporate officer? Okay, so you'll say, the position is not in the bylaws of chief accountant. It was not created by virtue of a board resolution. Was the appointment by virtue of a board act by the board of directors of the company? The answer is no. She was merely appointed by the president of the corporation. Was her dismissal as such, in that position, by virtue of a board act? The answer is no. She was dismissed by the same president of the corporation. Therefore, your conclusion is, she is not a corporate officer. Therefore, the last conclusion is, on the query of jurisdiction, you will safely answer that it is the labor arbiter that has jurisdiction. Now, later on, we will discuss employees of international agencies or especially specialized agencies of the United Nations. Their employees are not covered by the provisions of the Labor Code as amended because of the immunity granted to these international organizations and to these specialized agencies of the United Nations. So our Labor Code provisions do not apply to the employees of the Asian Development Bank, for example. And supposing X was dismissed by ADB, a Filipina. If the Labor Code provisions do not apply, what is her recourse? There are internal mechanisms within the Asian Development Bank for the adjustment of the disputes between Ms. X and the Asian Development Bank or similar entities. The point that I'm driving at is that Labor Code provisions do not apply to her, including to the extent of municipal laws not applicable to remedy her plight. There are internal mechanisms within ADB that will serve to adjust their disputes. So this specialized agency of the UN would, similar to this would be example of the World Health Organization based in the United Nations Avenue, the UNDP, the United Nations Environmental Program, UNEP, UNIDO, okay, and the rest. The hired employees there are not covered by the provisions of the Labor Code as amended. So, one more in the introductory portion before we go to Book 5. Okay. So when you will be answering your problems in labor, you also append the phrase, the Labor Code, comma, as amended, to appear impressive and to convey to the examiner that the Labor Code had been amended or superseded several times. So when you cite the Labor Code, let's say the article number, then of the Labor Code, comma, as amended. You append as amended. Okay. So don't forget. I asked one student the other day, what should you append after the Labor Code to appear impressive? Then he told me, sir, the phrase is, the Labor Code, bid as amended. What is bid? Comma, sir. Okay, so don't forget to also append that phrase as amended. Okay. The last one would be on money claims. Anyway, we will amplify this as we go along, but I'm telling you that this could already be the focus of the examiner. On money claims, your choice is labor arbiter or the regular courts, the appropriate regular court. The Supreme Court, in several cases, many of them, had already firmly decided on this, how to determine which of the two will have jurisdiction over money claims. Okay. So I'm calling your attention to the reasonable causal connection test. The reasonable causal connection test. Okay. And maybe for 5 minutes, I'll introduce you again to labor standards. Here is Miss X. He claims that X Corporation did not pay her salary differential. So what's a salary differential? She claims that she was receiving below minimum wage. The difference between what she is receiving below minimum wage and the prevailing minimum wage is salary differential. The difference is known as salary differential. So she's claiming that she was not paid the difference. She's also claiming that during the 24 hours period that she is working, you call that a work day. So what's a work day? It's a 24-hour period, usually starting from the work shift of the employee and ends at the start of the work shift the next day. Okay. So if an employee works for 8 hours during the first shift and works for another 2 hours on the third shift, that is overtime, and that is also night shift work because it was done during the 24-hour period. Okay. As contrasted to a calendar day. So you'll be asked, what's the difference of a work day and a calendar day? Work day starts from 8 a.m., that's the start of the shift, and ends 8 a.m. the next day. While a calendar day starts at 12 midnight and ends 12 midnight the next day. It's also a 24-hour period. May a work day be at the same time a calendar day? The answer is yes, if the work shift of the employee starts at 12 midnight, but this is rare. Okay, so and for the purpose of labor standard, you will be asked, which matters, a work day or a calendar day? Of course, it is the work day that matters. So any work done during the 24-hour period, 8 hours, after 8 hours work, provided that the work was done within 24 hours during the work day, the employee is entitled to overtime as well as night shift differential pay because the last 2 hours were rendered between 10 p.m. up to 6 a.m. the next day. For your MCQ, night shift is also graveyard shift. When an employee works at night shift or in graveyard shift, he is paid a night shift differential pay. He is never paid a graveyard pay. There's no such animal in Book 3. Unless the employees of Loyola Memorial Park, okay, who works from 10 p.m. up to 6 a.m. the next day, would volunteer to be buried alive. Okay, that's the only time maybe that they will be paid the graveyard pay. Okay, so there is no such thing as graveyard pay. So this is claimed by Miss X as not paid by management. Okay. Then comes now the concept of premium pay. Premium pay. What's a premium pay? There are days that the employee is not supposed to work. For example, it is the rest day of the employee. As a general rule, you cannot be compelled as an employee to work on your rest day. Likewise, on a special day declared by Malacanang as a non-working holiday, you are not supposed to work on that day as a general rule. And then it's a regular holiday. It's May 1. You are not supposed to work on that day as a general rule. But having been made to work on these days, for the first 8 hours, it is the rest day of the employee. For the first 8 hours, he is entitled to his regular wage plus 30% thereof. So, regular wage plus 30% thereof. This 30% additional compensation is the concept of a premium pay. That is a rest day premium pay. Again, this is a motherhood statement. This will for sure come out in the bar. A special day declared by Malacanang as a non-working holiday. Examiner will ask, the employee does not work on this day. Is he entitled to regular wage? He is not entitled to his regular wage. But if he works on this day, then for the first 8 hours, he is entitled to his regular wage plus 30% thereof. This 30% is known as a special day premium pay. Okay, and lastly, there are days which is a special day declared as a non-working holiday, and at the same time the rest day of the employee. As a general rule, he cannot be compelled to work on that day. But having been made to work on this day, subject to the exceptions provided for under the code, he will be entitled for the first 8 hours to his regular wage plus 50% thereof. This additional 50% is known as rest day, special day, premium pay. Okay. So, on a special day declared by Malacanang as a non-working holiday, if the employee does not work on this day, he's not entitled to anything. It's only when he's required to work on this day, by way of exception, that is entitled for the first 8 hours to his regular wage plus 30% thereof. This 30% for the last time is known as a premium pay. But since it is rendered on a special day, it will be denominated as a special day premium pay. And finally, one is not supposed to work on a May 1 because it is a regular holiday. But having been made to work for the first 8 hours, he is entitled to his regular wage plus 100% thereof. Total 200%. That additional 100% for the first 8 hours is the concept of a regular holiday premium pay. Now, here is the comparison. If the special day is not work, so you will also encounter maybe the word unwork, UN, unwork, he is not entitled to anything. But if it is a regular holiday, May 1, the employee does not work, he is entitled to his regular wage, only 100%. But if he works on this day, he is entitled to 200% or twice his salary. Okay, all of this are now claimed by Miss X in the determination on her money claims, where to file the same. So silently in the bar examination room, you will now ask yourself the reasonable causal connection test. These claims by Miss X, do they have a reasonable causal connection with what? With the motherhood statement, with employer-employee relationship. If there is a reasonable connection with employer-employee relationship, these unpaid amounts were earned during the existence of employer-employee relationship, labor arbiters jurisdiction. Otherwise, no jurisdiction for the labor arbiter. Okay, in that case, these were earned during the relationship. it has a reasonable causal connection, this money claims, with employer-employee relationship. Therefore, the labor arbiter or labor tribunals have jurisdiction. Okay. And the last example on this, maybe this is the one that will be asked, is also a jurisdiction. The sales manager of a motor sales company was extended 50,000 spare parts on his car and 25,000 service on his car. Total 75. After 3 months, the sales manager does not want his salary deducted. So the company president now asks you, where shall we file our case? Labor arbiter or with the appropriate regular court? Then you tell him, as your client, your claim is a simple claim for a sum of money. It did not arise from employment. This was not earned by the sales manager during employment. As a matter of fact, this is a loan that you extended to him. Therefore, there being no reasonable causal connection of your claim with employer-employee relationship, although the sales manager is their employee, your advice will be, it will be filed with the appropriate regular court to the lower court. Okay? Not with the labor arbiter, because of the absence of the connection of this money claims with employer-employee relationship. Okay. As we go along, we will add areas of jurisdictional conflict. Okay. So one more topic before we go to Book 5. If there is a constitutional provision that will be again asked once more, it is Section 3, Article 13. Please mark this. Section 3, Article 13. Why? Because in the last 6 years, questions were asked from Section 3, Article 13 of the 1987 Constitution. What was the area of the question asked? It's part of your syllabus today. First, Section 3, Article 13, it is 211G of Book 5 and 255, old numbering of the Labor Code. Okay, these are the three provisions. Section 3, Article 13, 211G, and 255 of the Labor Code. By the way, Justice Brion adopted the old numbering of the Labor Code. He did not adopt the new numbering for the purpose of this year's bar. But just to give you an idea, the amendatory law changing the numbering of several books in the Labor Code is Republic Act number 10151, which took effect June of 2011. So please take note that there were no changes in so far as Articles 1 to 129 is concerned. 1 to 129 is the same. No blackboard yet. We need a blackboard this afternoon to outline jurisdiction. Okay. So again, it's 211G. Okay. So the first question on this refers to the right of the workers to policy and decision making affecting their rights and benefits. So this is found in Section 3, Article 13, and this is the same right that is fleshed out as a declaration, as a declared policy in 211G of Book 5, and further fleshed out in 255. Okay. So that was the first question in the bar during the last 6 years. The question was, what is this right to codetermination? So the right to codetermination, maybe it will be asked in the multiple choice section of your bar exams, is no less than the right of the workers to policy and decision making affecting their rights, welfare, and benefits. Okay. Now, just to expand further this right to codetermination, this refers to the right of the workers and employees to policy and decision making. Then, the wife of former Senator Joker Arroyo, Felicitas Aquino, asked Vic Foss, attorney Vic Foss, another delegate in 1986, as to what is the meaning of codetermination and whether this codetermination, which is participation in policy and decision making, is the same concept as in Europe and in Japan, where the head of the union participates in the corporate board. The answer was no. This means membership in voluntary associations like labor management councils and the like. Okay. Then came another bar exams under Section 3, Article 13. I'm calling your attention because it may be asked in a different manner, but the same gist being asked. Okay. The next year is, what is the extent of this workers' right to policy and decision making? Okay. The extent is extends to all those affecting their rights, welfare, and benefits, but excluding therefrom those reserved to management under the concept of management prerogative. Management prerogative, as you had observed in the 2013 bar syllabus, is a main topic by itself in the 2013, 2012, and 2011 bar syllabus. Okay, so what's not included in this workers' participation to policy and decision making affecting the rights and benefits would be those reserved to management, the rights known as management prerogative. So you will expect a problem on management prerogative. So let's discuss management prerogative for 1 or 2 minutes. This means that when an investor, a businessman, puts up a business, his main motivation is to rake profits, is to earn profits. Okay, is to earn profits. And therefore, as a businessman, an investor, he knows best what to do with his business enterprise. He will now determine the price of his products and services. He will determine who is to be hired, who is to be discharged, who is to be laid off, who is to be promoted, who is to be transferred from this place to another place, all in the name of management prerogative. And the examiner will continue to ask you, is this right of management absolute, that management can do anything that it wants with its business enterprise? True, businessmen may close their business even if it is not losing, but there are limitations to the exercise of this prerogative. All the memory aids contain these limitations, but let's just discuss the 5 limitations. Okay. In order that Management Act will be upheld as a valid one, the first limitation is it must not be exercised in bad faith. So if it is exercised in good faith, that is to be upheld as a valid exercise of that prerogative. But if it is exercised in bad faith, that serves as a limitation to the exercise thereof. And then number two, the limitations that the act of management should not be tainted. There must be no indication that there is unfair labor practice committed. Okay. Now, when we reach 247, 248, 249, we'll have all the details of this. But the preliminary discussion on unfair labor practice. Okay, so Management's Act must not be tainted with unfair labor practice. Because if there is unfair labor practice, then that will serve as a limitation to the exercise of management prerogative under number 2. Okay. Now, please take note. If ever there will be a problem on unfair labor practice of management that will be asked this October, ask yourself silently. This alleged act committed by management, does it violate the workers' and employees' right to self-organization? Does it transgress the workers' right to self-organization? Okay, so let's go to two examples. A was employed by A corporation. He was dismissed by A corporation. So he went to the labor arbiter and filed a case for illegal dismissal and ULP against A corporation. Note that in A corporation, there is no union. A does not belong to a union. There is no indication that one is being formed. So in that case, A's right to self-organization was not violated by management. And so, that aspect of ULP will be dismissed by the labor arbiter, and if at the worst he was illegally dismissed, he is entitled only to the first aspect of ULP, which is the administrative and civil aspect thereof, but no criminal aspect. What is that? He will be reinstated, plus back wages, plus moral and exemplary damages and attorney's fees, but no criminal aspect. Why? Because his charge of unfair labor practice has no basis. His right to self-organization was not violated or transgressed by management. Okay. Now, here comes employee B. He was employed by B Corporation. B was an active and militant union organizer. He was able to organize the union in B Corporation. In order to cut him off from his organizing activities from Metro Manila, he was suddenly transferred to a faraway branch office of B Corporation in Mindanao, thereby clearly establishing the fact that his right to self-organization was violated by management. So he files now a case for illegal dismissal via ULP, or ULP via illegal dismissal. In this case, there is not only an administrative or civil aspect thereof. The arbiter now will rule that he was illegally dismissed, is entitled to back wages, and if there's a hearing on the merits, to moral and exemplary damages and attorney's fees. And when the civil aspect shall become final and executory, then B can now file the criminal aspect of the ULP with the appropriate prosecutor's office. Now, imagine a 1-year period. So why am I telling you that there is a 1-year period? This is the prescriptive period for unfair labor practice based on Article 290 of the Labor Code. 1 year. So if B filed his action for ULP against the corporation, B Corporation, 30 days after the commission, there is a balance of 11 months. So what happens to the balance of 11 months if a case for the civil and administrative aspect of ULP is filed before the labor arbiter? In that case, the balance of 11 months will stop to run. So you imagine the 12 months period. B filed the ULP 30 days after commission. There's a balance of 11 months. What is the effect of filing that civil aspect with the labor arbiter? It will stop the 11 months balance. Okay. When will it run again? The examiner may ask you. When that finding of the labor arbiter in the civil aspect becomes final and executory. So the criminal aspect must be filed within the balance of 11 months. Otherwise, prescription shall have crept into the picture. Why? Is prescription a creeping thing? That's why I use the word prescription, crept into the picture, or prescription shall have entered into the picture if not filed within the balance of 11 months. Now, lastly, for this general concept, why should be filed the civil or administrative aspect before the labor arbiter? Because according to Article 247 of the Labor Code, that is the condition sine qua non. That is the condition precedent before you can file the criminal aspect of ULP. Because you cannot file directly the criminal aspect of ULP. Even if the civil aspect is still pending, you file the criminal aspect, it will be dismissed by the prosecutor. On what ground? Like a baby born before 9 months, it will be dismissed due to prematurity. So lastly, you will ask in a collateral manner, what is the condition precedent before you can file the criminal aspect of ULP? You must file first a civil or administrative thereof with the labor arbiter. Why? What's the jurisdiction of the labor arbiter on ULP? It's in 217A1. We'll discuss this in a few minutes. So later on we will, so we are in number 2. It must not be tainted with unfair labor practice. Because if the act of management is tainted with unfair labor practice, that is a limitation to the exercise of management prerogative. Later on, we will learn that there are 2 kinds of strikes. ULP strike, which is a political strike, and economic strike, which is also known as bargaining deadlock strike. Okay. And do not forget the second limitation. Should be tainted with unfair labor practice. By the way, do you know that ULP is a political question? Aside from the fact that a ULP strike is a political strike. Because it is asking you the question, are you a member of the Liberal Party? You, LP? Okay, so it's a political question. So that's 217A1. The third limitation, possibly, is that the limitations set by law. The limitations set by law. That's the third limitation to the exercise of management prerogative. Example, as a general rule, in the determination of the rest day of the employee, based on Article 91, it's management that determines which rest day, okay, will be the rest day of the employee, applicant employee. But, okay, this is the but item. The law provides that if that employee objects to the choice of the employer as a general rule, of his rest days, the employer, according to the code, please underline the word, must respect that choice based on religious grounds. So there is now a stalemate between the management and this employee who is about to be hired because of the choice of the employer of this rest day. But the rules provide for a compromise. In a month, there are 4 rest days, 2 choice of the employer, 2 rest days, choice of the employee. So this is in the rules. And the employee must notify the employer at least 7 days in advance of his choice of rest days. So here, although management has the right to determine the rest day of the employee, the law limits that exercise by saying that if there is religious objection by a religious objector, then management should respect the same. The law therefore limits the exercise of that management prerogative. Okay, supposing the examiner will give you a hypothetical example and ask you, all of you are employers, before you is a would-be employee, an applicant, and then you are now talking on negotiating on the rest day of the employee. Employee now objects on the ground of religious reasons. So employer should respect that choice. And then you ask him, why? In your religion, what should be the rest days? Okay. Then it tells you, sir, in our religion, we rest from Monday to Sunday. Okay, will you hire him? Okay, so law has a limitation to the exercise of management prerogative. And the 4th one, the limitation set by the collective bargaining agreement. All those that is found in the collective bargaining agreement generally was based on an agreement, based on a consensus on the meeting of the minds of the representative of management and of the union. And once integrated in a collective bargaining agreement, that is a CBA, management cannot just change that. For example, they agreed on the shift of certain employees from 8 a.m. to 5 p.m. Management cannot unilaterally change the morning schedule and transfer it to the 3rd shift or 2nd shift. So that is limited by the collective bargaining agreement. Or the union and management is stipulated for benefits, which is an improvement of Book 3. So the minimum benefits, which is the basis of the collective bargaining agreement, would be Book 3 benefits. Okay. But if the union and management stipulates below standard, what do you mean by below standard? There are 5 days incentive leave in Book 3. They now reduce this to 2. There are 11 regular holidays. They reduce this to 5. These are below standard benefits, and you call that a sweetheart CBA. So what's a sweetheart CBA or sweetheart agreement? It's a collective bargaining agreement that stipulates below standard. So note the 4th limitation, the limitation set by the collective bargaining agreement. And the last one, it's all in your memory aid, the limitation set by the principle of justice and fairness. The principles of justice and fairness. If you can internalize this 4, I'm sure you can have a very good answer on this subtopic known as management prerogative. But the examiner will not ask you the limitations set by the principles of fairness and justice. Where is fairness fairness lodge? Heart or mind? Where is justice lodge? Mind or heart? Okay. So let's leave now the topic on management prerogative as an initial salvo, okay, on your areas of jurisdictional conflict and general principles. Okay. Labor relations is Book 5, including Book 5 rules. Labor standards covers almost all, including Book 6 and post-employment. Okay. Don't worry on the numbering of Book 5, Book 6, and Book 7. Why? Because as I've said, Chairman Brion is still with the old numbering of the code. But if you want to impress him, all that you have to do is to add 6. For example, in Book 5, it starts with Article 211, the policies. You add 6, it now becomes 217. And then place a bracket there as renumbered. Jurisdiction of the labor arbiter, 217 plus 6 is now 223. Jurisdiction of the NLRC, 218 is now 224. Same is true in Book 6. You add 6. In Book 7, you add 6. That is the new numbering. Okay? So don't worry. Even 263G, a sure bet in this year's bar. The assumption powers of the Secretary of Labor is found in 263G. Plus 6, it is 269G. Okay. So first, Book 5. You will be asked first the parties to labor relations. The parties to labor relations. The main parties would be labor and management. Labor collectively and management, also known as capital. The two main stakeholders in labor relations. Up there would be the government agencies, the institutions that regulate their relationship. So you have there the Secretary of Labor, the Regional Director of the DOE, the Bureau of Labor Relations, the Med Arbiters, the Labor Arbiter, the NLRC divisions, okay, NCMB, and the like. So these are the government agencies. And the fourth stakeholder in labor relations would be the public. So public is the fourth. So these are the four stakeholders in the area of labor relations. You'll also be asked in your historical bar type question, why is it that there is a continuous dynamics or interaction between labor and management? Why is it that there is a continuous friction between labor and management, that even if a CBA, a new one has just been signed by the parties, there is now an agitation once more in the plant level? Okay. This is because the workers and the employees would like an additional share in the profit pie. So two main reasons why this friction or interaction continues in the plant level. Number one, the incessant demand for increased wages and salaries. That's causing the friction or interaction. And number two, the incessant, the unstoppable demand for better working conditions. That's causing the interaction, the continuous dynamics, or friction between labor and management. Maybe we should have a blackboard so you can visualize the flow of the jurisdiction. You can visualize the options of the Secretary of Labor on an assumed case and a certified case. I'll be in the second half of this morning's session. I'll require a blackboard. Okay. So let's go first to the NLRC. March 1989 is a cutoff date when Republic Act 6715 took effect. And 6715 is a law that is known as the Herrera-Veloso Law. So it introduced several amendments in the Labor Code. And the most notable of the changes would be an independent NLRC. Because before 21 March 1989, the NLRC was headed by the Secretary of Labor in an ex officio capacity. So as Secretary of Labor, he is automatically then the chairman of the NLRC, aided by a vice chairman. Okay. Then came 21 March 1989. There was now a separate chairman of the NLRC, and today there are 8 divisions. So there's 1 chairman and 23 commissioners. The first 6 divisions are based in Metro Manila, and the composition is tripartite in composition. Okay. Presiding chairman comes from the government sector. The 2 are supposed to be coming from the employers and workers sector. But it's also in the code that once the nominee of the employers sector and the workers sector have been appointed by the President of the Philippines, they must now cut the relationship with the nominating sector where they come from. So composition is tripartite in composition. The last 2 divisions is based in Cebu, and the last one is based in Cagayan de Oro. You may be asked this October, prior to 21 March 1989, when the Secretary of Labor was still the chairman of the NLRC, cases were also decided and banked after they come from the divisions of the NLRC. That arrangement no longer works because decisions in the NLRC today is through its divisions, 8 divisions. There is no more decision of cases and bank. Let's take note of that. Okay. No more decisions and bank. But the NLRC may still meet and bank on 2 matters. 2 matters, but never to decide cases anymore. Number 1, to decide matters affecting the operations and administration of the NLRC as a whole. Number 1. Number 2, to promulgate rules of procedure that will govern both the NLRC divisions and the labor arbiters. But they don't meet anymore to decide cases. Now, part of your notes should be the qualification of the chairman and the commissioners. There must be a member of the Philippine Bar. Then there must be in the practice of law for 15 years, 7 years devoted to the area of labor relations. While the executive labor arbiter or the labor arbiter should have practiced for at least 7 years, 3 years devoted to labor relations. Okay. So have a working knowledge of their qualifications. There was one case after the Herrera-Veloso law was passed in 21 March of 1989. And that law, the Republic Act 6715, provided in Article 213 thereof that the chairman of the NLRC and the commissioners thereof should pass confirmation by the Commission on Appointments. Okay, is that a valid provision still today? The answer is no. Based on the case of John Peter Calderon versus the Honorable Bartolome Carade, a former chairman of the NLRC, the Supreme Court ruled that there is no need for the confirmation of the chairman and the NLRC commissioners. Otherwise, that law would add an additional group of presidential appointees appointed by the President that should pass the Commission on Appointments, confirmation by the CA. That was declared unconstitutional in the case of Calderon versus Carade. All the others before 217 and 218 are reading matters. They're easy to read. What's a reading matter? A reading matter is something that should be read. Okay, so okay, all of these are simple reading matters. Let's go now to the jurisdiction of the labor arbiter. For sure, as the sun rises in the east and sets in the west, problems will be asked on 217 and Article 218, the powers of the Commission. So let's analyze the powers of the labor arbiter first. 217 is divided into three subdivisions. First is 217A, the jurisdiction of the labor arbiter. 217B, the exclusive appellate jurisdiction of the NLRC division. And C, the first part of the jurisdiction of the voluntary arbitrator. The voluntary arbitrator. So A, B, and C. So we go first to letter A. During our time, we did not pay much attention to a phrase that introduces the jurisdiction of the labor arbiter in 217A. And the phrase is, we call it today, the accepting phrase. The phrase is except as otherwise provided under this code, comma, the labor arbiter has original and exclusive jurisdiction over the 6 enumerations that follows. The first one is unfair labor practice. The number 2 is termination disputes. And the third, as compared to the 6, refers to money claims. The difference is, in the jurisdiction of the labor arbiter in number 3, there's a claim for restatement. In number 6, it's because of the amount, whether there's a claim for restatement or not, that determines the jurisdiction of the labor arbiter. And then 4, this is the jurisdiction of the labor arbiter to award damages. There are 4 kinds there: actual, moral and exemplary damages, and other forms of damages. As we go along, we will discuss later nominal damages. The basis for the award of the labor arbiter for nominal damages, another possibility in the bar, because of the Agabon case and the Jaca case, is other forms of damages. And 217A5 is a is a very strong power conferred to the labor arbiter, the power to declare a strike legal or illegal, including violations of Article 264 of the Labor Code. Okay. So, we will go to this one by one. And then, let's go first to 218 so we can discuss what are the important parts of the powers of the Commission. If there are two sub-provisions that you should mark here, it is 218E, the injunctive powers of the Commission. And then 218B, the contempt powers of the Commission. The contempt powers of the Commission. Note that in 218D, the labor arbiter is also given the power, okay, to decide contempt cases. So there are two contempt cases here, direct and indirect contempt cases. First, by the labor arbiter, where he now decides a case for indirect contempt, and the penalty is 1 day imprisonment or 100 pesos fine or both at his discretion. This is appealable to the appropriate NLRC revision. Basis 218D. On the other hand, the NLRC division, including the chairman, may also adjudge persons for indirect contempt, where the penalty is 500 pesos and the imprisonment is 5 days or both. This is final and executory. It's not appealable. So as compared to the indirect contempt adjudged by the labor arbiter, that is subject to appeal. By the chairman or any of the commissioners, it is not subject to appeal. So it should now appear automatic to you that if contempt powers of the commission is mentioned, the sub-provision that should automatically hit you would be 218D. On the other hand, the injunctive powers of the Commission is 218E of the Labor Code. Now, get your notebook and try to write the 5 requirements for the issuance of an injunction or temporary restraining order. Why? At least you should substantially memorize the requirements for the issuance of an injunction or a temporary restraining order. Remember, there are plentiful of jurisprudence to the effect that in a petition or application for injunction, if you miss any of the requisites, which are jurisdictional allegations, that will be fatal to your application for injunction or petition for injunction. So in one case, the case of bisig ng manggagawa sa concrete aggregates, bisig ng manggagawa sa concrete aggregates, the Supreme Court ruled that failure to state any of the 5 requirements, as in this case of bisig ng manggagawa, the last 2 requisites was questioned by the union for concrete aggregates, against concrete aggregates for not complying allegedly with the last 2 requirements, that there is no adequate remedy at law, and number 5, that the police officers tasked to protect the property of the complainant is unable or unwilling to furnish the same. Okay, so take note that failure to state any of the 5 of these requirements is jurisdictional, and your petition may be dismissed. And in another case, the case of Hong Kong Shanghai Banking Corporation, and Hong Kong Shanghai Banking Corporation was represented by former Minister of Labor Bobit Sanchez, okay, according to the union in Hong Kong Shanghai Bank, they did not comply with the third requirement. As to the item of relief sought, who's to be injured more or less if not issued or issued? According to the union, this was not complied by Hong Kong Shanghai Banking Corporation. But the Supreme Court ruled that there was substantial compliance by the bank through its lawyers, because this third requirement, third requisite, was stated in some other pleadings of the bank. Okay? So, the point that I would like to leave with you is that all these 5 requisites, are jurisdictional allegations. And if in your application for injunction or petition for injunction, you miss any of these 5, it is fatal to the application or petition for injunction. Now let's go a little up in 218C. You will find there a power of the Commission. And the power is to waive any error, defect, or irregularity. The power to waive any error, defect, or irregularity in a case before it, whether this defect is in form or substance. Okay. And this is a relative provision in Article 221 of the Labor Code, that the labor arbiter and the NLRC divisions are not bound by the technical rules of evidence. They are not bound by the technical rules of evidence. So this provision should be read together. These 2 provisions, 218C, especially on the waiver of any error, defect, or irregularity, as well as the NLRC division and the labor arbiter are not bound by the technical rules of evidence. Okay, does not mean, according to the Supreme Court, that the NLRC division or the labor arbiters would do away with the basic or rudimentary principles of evidence. They should stick to the basic rules of evidence, even if they are not bound by the technical rules of evidence. Okay, let's go now to the jurisdiction of the labor arbiter. Number 1, unfair labor practice. Now try to underline the phrase, except as otherwise provided under this code. So, 4 years ago, in the bar exams, there were 2 difficult questions asked. May a case subject of voluntary arbitration be lost in favor of compulsory arbitration? So before you can answer the question, you must be able to distinguish what is compulsory arbitration and what is voluntary arbitration. Okay. When you say compulsory arbitration, you imagine a state institution, let's say the labor arbiter thereof. One of the parties will go to this labor arbiter, and the regional office of the NLRC, where the labor arbiters are housed, is known as the Regional Arbitration Branch. So the labor arbiters are there in a branch. If you go to Banawe, the NCR, Regional Arbitration Branch, is divided into 2. The demarcation line is Banawe Street. Although south of Banawe Street, you go and file it, the case in Bookman. It's just about 100 meters from Banawe. And those north of Banawe Street should be filed at the PPSTA building. Public School Teachers Association building. Okay. So that's where the Labor Arbiter holds office, either in Bookman or in the PPSTA building. So in reference to the accepting phrase, normally ULP is filed with the Office of the Labor Arbiter. So a union claims that they were victims of ULP, let's say a labor union, committed by a corporation. Based on the number 1 enumeration, Labor Arbiter has jurisdiction. But if later on, the Secretary of Labor, invoking parties to a strike, invokes the power of the Secretary of Labor under 263G, the plenary power to assume labor disputes, under 263G, and ULP is part of the main case, which is the strike, then the Labor Arbiter's jurisdiction is lost in favor of the Secretary of Labor in an assumed case. Based on jurisprudence, that is what is known as the principle of absorption, from the word absorb, or the principle of subsumation, from the word subsume. In other words, all pending cases before the Labor Arbiter or other labor tribunals are lost in favor of the Secretary of Labor. Why? Because it is provided for under this code, 263G. So in that case, even if that case was filed with the Labor Arbiter, he will lose jurisdiction over the same in favor of the Secretary of Labor in an assumed case. So that was the gist of the first question asked in the bar. And then another union filed ULP against management, B Labor Union versus B Corporation. Secretary of Labor did not assume the labor dispute because there was no strike staged by the union. So this was another bar examination. It was a difficult question at that time. By agreement of the parties, by the union and management, under Article 262 of the Labor Code, they agreed to submit the case to voluntary arbitration. So what is this voluntary arbitration? As a mode of settlement of disputes, a preferred mode. Two parties agree to choose a voluntary arbitrator, union and management. And if they choose two or more arbitrators, you call that a PVA, a panel of voluntary arbitrators. So by agreement of the parties, there's a consensus of that choice of the voluntary arbitrator by the union and management. In compulsory arbitration, it is the other party is compelled by the government agency to appear before it, subject to sanctions if the company does not appear. So here, compulsory arbitration, complainant files a case with the labor arbiter. Labor arbiter now compels the other party, the company, to appear before it. So there is now the element of compulsion. That's why compulsory arbitration. While voluntary, it is arrived at by the consensus of the party. So it may be decided by a panel or by the voluntary arbitrator. Now you may be asked, what is the nature of the function of the voluntary arbitrator? What is the nature of the function? He is an instrumentality of government. He is an instrumentality of government. Based on a case, the case of Luzon Development Bank, the Luzon Development Bank case. The nature of the office of the voluntary arbitrator is that it is an instrumentality of government. When a voluntary arbitrator renders a decision that is not subject to a motion for reconsideration, please take note. No more motion for reconsideration shall be filed on decisions of voluntary arbitrator based on Book 5 rules. So former Secretary Santo Tomas of the DOL deleted that portion where an MR was allowed. Okay. So you go directly to the Court of Appeals after receipt of the decision within 15 days. Okay. Under an ordinary appeal under Rule 43. Rule 43. So here, in that bar exams, many were not able to get the question. May a case subject of compulsory arbitration, a ULP case, lost in favor of a voluntary arbitrator, yes, by agreement of the parties under Article 262 of the Labor Code. And when that happens, even if the case was filed before the labor arbiter, he loses jurisdiction over the same in favor of a voluntary arbitrator. And why did the labor arbiter lose jurisdiction over this case? Because it is provided for under this code, under Article 262 of the Labor Code, to the deprivation of the labor arbiter of his jurisdiction under 217A1. Okay. Number 2, 1 and 2 case, please take note. Supposing the third case was filed by C Labor Union against C Corporation. There was no assumed case, so Secretary of Labor cannot exercise 263G rights. Parties, labor and management did not avail of 262 to submit the case to voluntary arbitration. Then we can truly say that in the case of Union C, filing a case against C Corporation, that it has original and exclusive jurisdiction over this ULP case. Why? Because the accepting phrase did not come into play. Okay. Then came another bar question. How about a case pending before a voluntary arbitrator? Can it be lost in favor of the labor arbiter? Okay, it was also a difficult question. For example, in a certain company, A was in the grievance machinery discussing company personnel policies, interpretation and enforcement thereof. Pending this case, A was dismissed by a final order of management. In that case, the voluntary arbitrator, despite the pendency of that case, will lose jurisdiction over this case in favor of the labor arbiter. So this is now another motherhood statement that you should not forget. In case the company dismisses an employee with finality, notwithstanding the pendency of a voluntary arbitration case, interpreting or enforcing provisions of company personnel policies, voluntary arbitrator loses jurisdiction in favor of the labor arbiter. So all final orders of dismissal, once it becomes a final order of dismissal, labor arbiter under 217A2 has jurisdiction. So don't forget, second jurisdiction is termination disputes. Termination disputes. The initial TD. T, don't forget. Number 1, ULP. Number 2, termination dispute, TD. What is TD? Termination dispute. Memory aid. It is the nickname of a person in the Visayas. His name is Teodoro. Nickname TD. Okay, so don't forget. Enumeration number 2. That's how he is called in the Visayas. It's not Teddy. TD. Okay. Okay, the third one would be money claims, where there is a claim for reinstatement. Okay. And then number 4, damages. Damages. The 4 kinds of damages that the labor arbiter may award would be, first, actual damages. Then next would be moral damages. Then exemplary damages, and other forms of damages. Other forms. Okay. Other forms of damages. It is in this last other forms of damages that nominal damages, okay, were awarded by labor arbiters. Okay. So let's go to nominal damages. There are 2 notable cases on nominal damages. Agabon and Agabon, and the other one is Jaka. Jaka Foods. It's the Agri-Food Corporation owned by JPE. So Jaka, J, Jackie, K, Katrina. Jaka. The AA there is Alfie Anido. Okay, don't forget. Okay. The Agabon case specifically applies to just causes. The Jaka case applies to authorized causes. And the nominal damages are different. In the Agabon case, there was a dismissal based on a just cause. Abandonment of the 2 Agabons, decided in 2004, and they were not accorded due process by the company. So, in this case, the Agabons were out of work for a just cause, but because management did not accord them due process, each of the 2 Agabons were awarded 30,000 nominal damages. While in the case of Jaka, the nominal damages was 50,000. Just causes, 30. Authorized causes, 50. What's the difference, you may be asked, in the bar? In the case of Agabon, which applies to just causes, both parties were at fault. The Agabons were guilty of abandonment of their jobs, while the company is also guilty of not according them due process. So in this case, the nominal damage is 30,000. The Agabons are out of work. Their dismissal was for a just cause, but because there was no due process, company was penalized for 30,000. In the case of Jaka, it is 50,000 because when a company has an authorized cause under 283, any of the 3 authorized causes, redundancy, introduction of labor-saving device, closure for reasons other than serious business losses, the employee or the worker has nothing to do with the decision, for example, to close a branch of the office, to abolish certain positions, or to introduce labor-saving devices. They have nothing to do. That's why the nominal damages would be higher by 20,000. It's 50,000. So for just causes without due process, 30. For authorized causes without due process, it's 50,000. Now, last question on damages. May the labor arbiter award in a labor case moral damages alone? The answer is yes. May he award moral damages plus exemplary damages? He can do that. But can he award exemplary damages alone? He cannot do that. That's not allowed. Moral damages alone, yes. Moral and exemplary at the same time, yes. Exemplary damages alone, that is not allowed. Okay. So the fifth jurisdiction is the power of the labor arbiter to declare a strike as legal or illegal, as well as violations under Article 264. What are these violations under 264? Violations during a strike, during a lockout, and during the engagement in concerted activities. Okay, so labor arbiter has jurisdiction over the same. What are jurisprudence of note on declaration of strike as illegal in relation to the accepting phrase? Okay. In the early 90s, there was this case of PAL versus Drilon, Philippine Airlines versus Drilon, which at that time, the Supreme Court ruled that Drilon, as Dole Secretary, committed an ultra vires act. Okay, what was the ultra vires act? There was a case for declaration of the strike as illegal filed by Philippine Airlines before the labor arbiter. Thereafter, the union in PAL staged a strike, and it was assumed by then Secretary Drilon. So Secretary Drilon did not only decide the main case, which is the strike, he also decided the action to declare strike illegal before the labor arbiter. But this is no longer a good case, as I've said. The Supreme Court ruled in that first case, it was a good decision at that time, that Secretary Drilon exceeded his authority because the action to declare strike illegal, according to the Supreme Court, is within the original and exclusive jurisdiction of the labor arbiter under 217A5. Thereafter, two cases followed, in effect superseding the case of PAL versus Drilon. What are these two cases? International Pharmaceuticals Incorporated versus Secretary of Labor. Here, there was also an action to declare strike illegal before the labor arbiter. There was also a strike stage, and there was also a petition to assume jurisdiction. Here, the parties made known to the Secretary of Labor of a pendency of an action before the labor arbiter. Another case was St. Scholastica's College versus Torres. Torres was a former Secretary of Labor. There was a strike, there was a case filed to declare strike illegal in by St. Scholastica. Then there was a strike staged then, and it was assumed by Secretary Torres, former Secretary Torres. So all the cases before the labor arbiter was absorbed by the Secretary of Labor. Under again the principle of absorption of all pending cases, or under the principle of subsumation of all pending cases. In that case, both the main case and the action to declare strike illegal was decided by former Secretary Torres and the previous Secretary of Labor before him. In effect, they can decide cases under 217A5. Why? Because it is provided for under this code, under 263G and jurisprudence, that if there are pending cases before the labor arbiter and there is a main case related to it, all pending cases are absorbed under the principle of absorption or subsumed under the principle of subsumation to the Secretary of Labor, okay, of all pending cases before the Labor Tribunal or before labor tribunals. Okay, so don't forget, International Pharmaceuticals versus Secretary of Labor and St. Scholastica's College versus Torres. Okay. So do you know where St. Scholastica's College is located? Okay. It's located in Vijoque Street. Do you know where Vijoque Street is? In Singalong. Do you know where Singalong is? Okay. It's in that part of Manila. It's in Singalong, Manila. Okay, so... And lastly, before we take a break, 217A6. This should always be read with Article 129 of the Labor Code. This is the area of jurisdictional conflict that will for sure be asked by the examiner this October. What is 129 of the Labor Code? And what is 217A6? Okay, these are the jurisdictions of 129, Regional Director to adjudicate small money claims. How about 217A6? Jurisdiction of the labor arbiter to adjudicate money claims. The only question that will be asked by the examiner, but we will discuss the concept, is there a shared jurisdiction in the adjudication of money claims between the regional director under Article 129 and the labor arbiter under 217A6. Okay. Now, please note, if you have been reading the earlier case of June of 1989 of Bryant Agro and LM Camus Engineering, that case had already been superseded because before the Supreme Court ruled that there is shared jurisdiction because of Executive Order 111 promulgated 24 December in the eve of Christmas in 1986. Because according to the Supreme Court, under that executive order issued by Tita Cory, care of Joker Arroyo, the purpose of Executive Order 111 is to make available as many officers of the dole to the working men. Okay. In a motion for reconsideration filed by two companies, in that case, LM Camus Engineering versus and Bryant Agro versus De La Serna. De La Serna was an acting Secretary of Labor then. The Supreme Court ruled that there is no more shared jurisdiction. Why? Because the requisites are clear in Article 129. That if all the requisites are present, that is to the exclusion of the labor arbiter. Regional director takes cognizance of small money claims. So the first requisite under 129 is number one, any employee or those in the household service, okay, brings the action. At first we thought that this provision is only for domestic helpers. No. It can also be any employee with a small money claim because of the disjunctive word or. Any employee or those in the household service. Then there are money claims which arose from employer-employee relationship which does not exist anymore. 3. No claim for restatement. The amount of claim does not exceed 5,000 pesos. If all these 4 requirements are present, regional director takes cognizance of these small money claims to the exclusion of the labor arbiter. Okay. But if there's a claim for reinstatement, labor arbiter has jurisdiction. If the amount is in excess of 5,000, labor arbiter has jurisdiction. All requisites are present, regional director excludes the labor arbiter. Why? Because of the accepting phrase. Because it's provided for under this code in 129 that if all the requirements for small money claims are present, labor arbiter is deprived of jurisdiction. And one last item before we take a break. There are 3 complainants in a case. Their claims are as follows: 7,000, 8,000, and 3,000. Total 18,000 by A, B, and C. All domestic helpers. No claim for reinstatement. They have money claims that arose from employer-employee relationship that does not exist anymore. Okay. So the employer bid was to file a motion to dismiss by adding 7,000, 8,000, and 3,000. Total 18. He concluded, labor arbiter has jurisdiction. Is the totality rule, the totality of the 3 claims in this joint complaint, determinative of jurisdiction of either the regional director or the labor arbiter? The answer is no. The basis based on Article 129 of the jurisdictional amount is the aggregate amount of each complainant's claim. Of A, 8,000, B, 7,000, and C, 3,000. If a motion to dismiss is filed by the employer of ABC, all domestic helpers, on the ground of jurisdictional amount, what will be your decision as regional director where this case was filed? Insofar as complainants A and B are concerned, you will grant the motion to dismiss. Because of the jurisdictional amount, as regional director, you are telling the whole world that the labor arbiter has jurisdiction. But insofar as C's claim is concerned, all the requirements are present, you will deny the motion to dismiss. You are telling the whole world that you have jurisdiction over this case to the exclusion of the labor arbiter. So again, before we leave Article 129, the basis of the jurisdictional amount is the aggregate amount of each complainant's claim, not the totality of their claims, because the totality rule does not apply to determine jurisdiction in a joint complaint before the regional director. So when you will be regional director, get only good encoders. The good encoders. Because here, the regional director was a victim of a bad encoder. So in his order, it was placed there. Wherefore, all caps, comma, promises considered. My God. And then in the last part, as paid for. It should be as paid for. Okay. So victim of a bad, encoder. So especially the male reviewers here, next year you will already all lawyers, especially the ladies here. But I'm telling you, the male reviewees, future lawyers next year, when you be there, hire only good secretaries. Don't hire better and best secretaries. There's a difference. You know the difference? Good secretary will say, in the morning, when she enters the office and sees you, she will say, "Sir, magandang umaga po." Magalang. She's the ideal epitome of a secretary. The better secretary will tell you better. So hire only a good secretary. Will say, "Sir, umaga na." So, shaking you up. The best secretary cannot pronounce the word "you" in umaga. So you say, "Sir, maga na." Okay, so get only good secretaries. So there is no shared jurisdiction between the regional director's jurisdiction to adjudicate money claims with that of the labor arbiter under 217A6. Okay, let's take a 5 minutes break to extend to 10 minutes. Okay.